Good morning, everybody. Thank you very much for coming today. We thought we might get started. We've got a lot of people that might do a little bit that have registered, but we will get cracking because we actually have quite a lot to get through. So we're here today for the ABCs of debt recovery. I'm going to be presenting today together with my colleague Nick Snow. I'm a director of the dispute resolution and litigation team here at DW Fox Tucker. And to be honest, we deal with quite a lot of debt recovery. Now, this presentation has been focused on small and medium enterprises, and we've tried to provide a relatively comprehensive guide on how to manage assumed debts. Now, just taking my lawyer hat off for a moment, I think sometimes it's very easy to forget how important these type of processes are for businesses. We know how hard it is already to run a business and how many hurdles you have to overcome. So by having some of these fundamentals in place, it's going to improve things like cash flow, reduce expenses, reduce liabilities and exposures. So it's actually quite a critical component of running a business. So I'll start off the presentation today. This is a bit of an overview of what we're going to look at. Now, the first topic we're going to focus on is contracting and best practice. These are the fundamentals, and these are the type of things that we want to make sure you get right from the outset. Then we'll move on to self-help remedies. So these are some of the things that you can do internally to recover any debts within a hopefully an effective and efficient manner. If that doesn't work, we'll then move on to seeing a lawyer and then what we need from you. Then we'll move on to court proceedings and then enforcement options. So the enforcement options is once you obtain a judgment, what you can do with it. So things like warrant of sale, payment orders, enforceable payment arrangements, things like that. So Nick will go over all those things. So contracting. I think the thing that I want to start off here is to say, from our perspective at DW Tucker, we like to take a very strategic approach, and we place a heavy emphasis on early action and resolution to disputes. So how does this relate to debt recovery? Quite simply, a good contract, happy ending, bad contract, not so good ending. Everything is literally in your contract. So having a clear and comprehensive contract is essential to preventing disputes or minimising disputes. A key tip is, and I know this seems pretty basic, but it's something we come across quite often, is to identify from the outset who the correct party is. Now, we know company structures can be quite convoluted and complex. So this even just comes from your perspective. If you're running a business, identify which company from you is actually the one providing the goods and services. Make sure that is correct. Then identify your client. Are they a company, partnership? Are they an individual? Make sure that is clearly documented in any contract and any invoice. In the contract, we also want to ensure that there are specific payment terms, such as your due dates, interest on overdue amounts, and in particular, the consequences if there is non-compliance with payment. So, for example, as a lawyer, we love to see a clause in there talking about the debtor's liability to pay costs in the event that you, the company, have to undertake recovery steps. Now, while also, if you're working with corporate clients, try hard to bear in mind a guarantee. You want a director's guarantee, some sort of security. One option to think about is a registration on the PPSR. Now, that's a whole new topic. I won't go over that. What I will say is the PPSR, the Act, the Personal Property Security Act, that is actually a fundamental piece of legislation that very few people have any knowledge about or very little knowledge about it. If you are supplying equipment, you're hiring equipment, highly recommend getting a bit of an overview on the BPSR because it is actually quite critical to your operation. I personally think it's quite an unfair piece of legislation. I'll put my personal views aside, but it is quite important to get your head around that. And it's also important if you end up in the insolvency. Now, we also want contracts to address things like indemnities, limitation of liability. We want clear rights to terminate services in the event that debts remain unpaid or invoices remain unpaid. I also recommend that you have these fundamental contracts reviewed by lawyers. The reason being is we have seen the introduction of unfair contract terms. Now, an unfair contract term, very briefly, is a term that causes detriment or imbalance to a party, and it isn't necessary to protect the legitimate interests, and it does, of course, cause detriment. And if that happens, your entire contract will be deemed unenforceable, and there are actually severe consequences in the event of a contract containing unfair contract terms. Again, that's another topic, but it is something that you need to consider when you are formulating these fundamental basic documents that you're basing your entire business off of. So self-help and self-help remedies. So this is what we would want you to do internally before, hopefully you don't see us, but before you do. Now, debt recovery, it really starts well before any debt arises, to be completely honest. We want a solid contract and clear terms, like we've just stated. You want to ensure that your invoices are promptly and regularly sent out. You don't want to have any, what we refer to as bill shock. That always ends up in a dispute. You want your bookkeeping records to be concise. We want to see when invoices are sent out, when payments are made, if payments are made, how much is outstanding. Keeping all approvals in writing and on record. So, for example, if you're in construction, you want to make sure that all of your documentation when it comes to negotiations and things like that, everything is in writing and you keep that on file with that client. Now, maintain a habit of consistent and documented follow-ups. Now, if that's via email, telephone, with contemporaneous file notes, of course, if via phone, letters. The purpose is that we want a very clear paper trail of showing your attempts to try to resolve this matter. Now, from my experience in litigation, as well as the insolvency realm, for businesses, stay on top of unpaid invoices. Now, I understand 1 or 2 invoices may slip through. Businesses have cash flow, I completely understand that. But if you have a client that is repeatedly not paying invoices, has 4 or 5 outstanding invoices, isn't answering phone calls, is only paying round figures of, let's say $5,000 towards a $20,000 invoice, you need to stop. You need to think very clearly about continuing to supply goods and services to that company. Because if you continue to provide goods and services to that company, you are only just continuing to increase your liability, okay, and your exposure in the event that they do end up going to administration or liquidation. What not to do? Don't break the law. Don't harass people. So avoid any behaviour that could be construed as harassment, which includes excessive follow-ups. Contacting clients outside of business hours, don't do that. Obviously, don't make this. And focus on a very structured and professional process. By doing those internal follow-ups, if you then don't resolve it through any actual genuine engagement, that's when we encourage you to then seek a lawyer. I get it, nobody wants to see us. I wouldn't want to see me either. But I will say it is actually quite cool.
The reason being is it escalates the matter and it just gets the intention. Now, when you do see a lawyer, what to bring? So we want to see things like any of your contracts, agreements, leases, licenses, any quotes, invoices, estimates, variations, evidence to actually demonstrate that you provided the goods and services. Provide us any evidence of payment, please. We don't want to say you owe our client 100,000 and they come back and say, no, it's only 50,000. We don't want to be wrong. And any communication that you have regarding non-payment. For example, we want to know, is there any dispute? So let's say you're a construction company, or construction company, and there's a variation, it wasn't in writing, but it was still undertaken. We want to know this type of stuff because it will streamline the process for us, and it will also enable us to try to engage in the process in the most efficient and effective manner. So what do we do first? We will send out a basic letter of it will be on our letterhead, and often we do hope that will be enough to escalate the matter to get somebody to start engaging us in this genuine manner. We'll also obviously review your documents. We'll identify helpful clauses, like I said, where we get to recover your legal costs from the other party for undertaking these steps. We'll also identify any potential problematic clauses. We'll identify proper parties to the matter. We'll advise you on your prospects of recoverability. To this, what I will just flag, side point, there are many searches that we can do to ascertain what assets a company has, what an individual has, or what property they own. So there are things that you can do in the background as well. And of course, we'll explore options for resolution. Now, before I delve into what we're going to do as the pre-action steps, I'm going to take a bit of a sidestep and talk about freezing orders. So a freezing order is actually a court order that stops somebody from moving, hiding, or disposing of assets. And this is assets, whether it be overseas or Australia. And so those assets become and remain available in the event that you get judgment against this company or person, and then you can have access to those assets. So it's very much designed to maintain the status quo of the situation. And like I said, to prevent people from shifting things around and avoiding paying creditors. But a freezing order is only granted in circumstances where we can very clearly demonstrate that we have a good and arguable case, which in this particular case would be obviously a payment, a debt recovery action. There's evidence that the defendant is actually trying to hide and shift assets. Can't be what we flowered up, actually.
No, they're handing them out at the ground floor.
So, for example, what you would want to look at is, so let's say there's Helene Proprietary Limited. I stop paying your debts, and then all of a sudden there's Helene No. 1 Proprietary Limited that's opened up. And you can see that all of a sudden my entire business has moved across to Helene No. 1 Proprietary Limited, and I start operating out of that, and I ignore you entirely in relation to the money that I owe you at a Helene Proprietary Limited. We could have things. That is the type of activity that the court wants to know about and that wants to see clearly evidence when considering whether or not to make these type of freezing orders. And we want to show the court that without that order, without a freezing order, there is a real risk that we won't get paid at the end of the day if we get judgment against Helene Limited. Now, these orders can actually be obtained at any stage. And the important part is they can actually be obtained before you commence proceedings against someone or a company. And it actually often happens without telling the other side as well. But what I will emphasise is this is a very serious step. Obviously, you're preventing a company or a person from using their assets without a judgment, without the court determining a matter. So it is a very high bar, and the High Court has actually referred to it as a dramatic remedy that should not be granted lightly. So it is a big hurdle to get over. Not to say we haven't, because we have obtained lots of freezing orders, but in the right circumstances. Now, the other option as well is prejudgment security. Now, that's if somebody is refusing to communicate, they're selling off assets, they're left their job, might be moving into state. You can ask for the court to make a protection order before you get a judgment. The court can order that the debtor pay money into court as security. And if there's evidence that they're about to leave the state, and that could hurt your chances of later getting paid. They can also summons the debtor to appear in court for questioning about their financial situation. If they fail to attend, the court can then issue a warrant for their arrest, making sure they get to court to answer these questions. It's available for monetary claims, so in these type of debt recovery matters. But what I will say is if you do have genuine concerns about the movement of assets or the selling off of assets, the freezing order, that's where we want to go. Now, we're at the stage where you have great documentation, of course. Unfortunately, somebody isn't paying you. You've tried through a professional and well-established process to follow up these invoices, and you're not getting any response. You've come and seen the lawyers. We've sent a letter of demand, normally say pay us within 14 days. Now, if that hasn't resolved the matter, we then move on to what we call the pre-action steps. Now, these pre-action steps were introduced relatively recently by the court under our new rules, Uniform Civil Rules, back in 2020. Now, the objective of the Uniform Civil Rules, the objective of the pre-action steps is that we're trying to get the parties together to try to resolve the matter before heading down the path of going to court. Court is a timely process. It can be a costly process, and it takes time out of your life and your business to pursue people through the court process. So we've introduced this pre-action step. Now, this process is twofold. So there's two avenues. The first one is a final notice, and the second one is the pre-action claim. Now, before I go into those two options, just quickly, the court hierarchy, which I'm sure most of you know, we have the Magistrates Court, District Court and Supreme Court. The Magistrates Court can deal with claims up to 100,000. They have the minor civil jurisdiction as well as the general jurisdiction within that bracket. The minor civil jurisdiction is any claims up to $12,000. That's a lot of money. So I appreciate that $12,000 to a business is a lot, to anybody is a lot of money. But you can't actually have legal representation in court when it comes to minor civil matters, and it's a no-cost jurisdiction. Then anything above 12,000 is into the general jurisdiction of the Magistrates Court. District Court and Supreme Court, if you have a claim of 120,000, you could go to the District Court. If it was a complex matter, you would then probably issue in the Supreme Court. Now, what we do is the pre-action steps, we have what we call final notice and then a pre-action claim. The final notice is when we issue on the basis that you have a reasonable belief that the claim is uncontestable and is not genuinely contestable. Now, we issue a final notice, and that is through it basically sets out your claim. And we lodge it with the court, and we get it back from the court, and then we send it off to the other side, and we say you have 21 days to respond and pay our debt. If you don't, we're going to then go to court. We have to do that under the court. So you have to either do a final notice or pre-action claim. If not, there can be cost implications in the court system. as well as the court can turn around and say, well, you can comply, go back and do it, because they're adamant that these processes work. Now, if the 500 notice doesn't work, we then move on to issuing a statement of claim, which is when Nick talked to you about that. But the other option is what we refer to as the pre-action claim. Now, we use a pre-action claim in circumstances where there may be an issue. So, for example, again, back to construction. Let's say you've built a home for somebody and they owe you, final instalment of 200,000, but they're claiming defects. You say these defects are nonsense, but there is a dispute there. So the pre-action claim is a very specific letter. It's sent on a without prejudice basis. That means that everything in it is confidential. It sets out specifically your claim. It must attach any of the documentation that you're relying upon. So, for example, any contracts, any agreements, variations, invoices. If you're claiming damages, you want to attach a schedule of the damages and how you calculated that. We will also include what we call a P3 form that just sets out an estimate of how much this is going to cost to go to trial. And then critically, it must contain an offer of settlement. Now, often our settlement offer is, you're making us go through this entire process. You owe us the $150,000 that you haven't paid us and that we're duly entitled to, plus our costs. Because normally by that stage, people are getting pretty annoyed. But it must contain that. And then the next thing that is utterly critical is it must set out an invitation for the parties to engage in a pre-action meeting. Must set out a date and a time for that to occur, preferably face-to-face. But if the parties do agree, we can do it via Teams or telephone. They're not as productive. The parties, I think all lawyers and the court recognise that face-to-face meetings are by far the most beneficial when it comes to trying to resolve matters. Now, that pre-action meeting is, like I said, confidential. What that means is whatever happens in those four walls stays in those four walls. The purpose is to try to resolve the matter, and in order to do that, an open forum is the best way for that to occur. If that doesn't work, pre-action meeting finishes, no good, we're still in a dispute. That's when we issue us. That's when we will talk to you about that. Now, the one other thing I'll touch upon is without prejudice communications. That is just communications that are exchanged between parties, titled without prejudice, and they have settlement discussions enclosed. So, for example, you owe me $150,000. I don't admit liability, but I appreciate this is a costly task. I'll pay you $150,000, like that. Those documents, like I said, they're confidential. They can't be disclosed. On that note, I will hand over to Nick, who's going to now talk to you about the court process and enforcement options.
My name's Nick. I'm a lawyer here at DW. I work in the litigation team with Colleen. Debt recovery is most of the time quite a large part of my job. I work on these basically every day, trying to recover funds from people whose bills aren't getting paid. We know that every business has bills that don't get paid, so it affects basically everyone. So, like Colleen said, we've now reached the stage where our informal and formal pre-action steps aren't working, so there's no option but to go to court. Beginning the proceedings in court is always done for debt recovery. It's basically always done by a claim and a statement of claim. So this is a type of pleading, which I will go through a little bit more detail later. But the claim and the statement of claim is where you set out all the facts of your matter in the document. That document tells them, like I said, the facts of the matter, why the other side is liable for the loss that you've suffered, and obviously the amount of loss that you have suffered. The claim is then filed with the court. They print out a stamped version, and that stamped version has to be served personally on the respondent if they're an individual. This means that there's no excuse for them not seeing it. You have to physically hand it to them or have an agent hand it to them. And in the instance of a corporation being the respondent, it's a little bit easier. You can send it to their registered address. That obviously involves doing an ASIC search to find out what it really is, because it might not necessarily be the business on South Road with their logo on the front of it. The respondents then have 28 days from that date of service to respond to the defence. If they don't respond to the defence, that's when we come to a default judgment. So our claims can be essentially split into two types of debts. You've got a disputed debt and an undisputed debt. Our undisputed debt is where we are on this slide. That can then be again split into our default judgment and our summary judgment. So a default judgment, like I said, is where the respondent fails to provide a defence within that 28 days. And it's probably best to think of this as a forfeit sort of judgment. They haven't complied with their requirements, and as long as you can prove that they were adequately served with the claim, you can apply to the court to have a default judgment entered, which means you essentially instantly get the judgment without ever having to go to trial, and then that judgment is what you can use to be enforced against the other party. If that default judgment is entered, the other side can apply to have it set aside, except this essentially turns on the court saying, well, why didn't you reply in the 28 days that you had to reply? They can't raise their normal defence, as in, I've already paid it. It has to be, well, why didn't you say that 28 days or however many days ago during that period that you had? The other type of undisputed debt that we have is a summary judgment. It's similar to a default judgment, but in this instance, the other side could still have filed their defence within those 28 days. This would usually be the case where they have filed their defence, but it's so plainly and obviously clear to the judge that their defence is basically hopeless, that the judge is happy to say, I'm content to enter judgment against you without this having to proceed to trial because you don't have a hopeless case in front of me. So this is obviously only done in very plain and obvious cases. If the other side does have a valid defence, they seem to have a decent case on, we now have a contested dispute. This contested dispute might also involve the other side filing alongside their defence a set-off claim or a counterclaim, or also known as a cross-claim. The most common example here would be for, say, I'm a building contractor, I have unpaid invoices, I take the other side to court and they say, well, you did a bad job building my house, so I'm withholding payment. In that instance, they would bring either a counterclaim or a set-off claim, depending on the circumstances, to say that my liability is zero or reduced because of the poor work that you've done. The full process of proceedings generally goes in this order. We have our pleadings, which, like I said, was the claim and statement of claim from the applicant, the defence from the respondent, and any cross-claim or set-off that might happen there. And then you also have the option for a reply to the defence. The parties will then generally undertake discovery next, which I'll discuss in a second. We get expert reports and a mediation will happen, not necessarily in that order. And then if all, I suppose, doesn't go to plan, because we'd like to avoid trial pretty much at all costs, it will go to a trial before a judge who will then make their judgment. But for each of these steps, like I said, the pleadings are claim, the defence, any counterclaim. They're formal court documents that you provide to the court stamps them, and they're really important because if your matter does proceed to trial, the pleadings are what define the case to the matters that you've put before the court, and you can't go outside of those pleadings if you end up at trial. So whatever you say in those pleadings, you're restricted to arguing on those bases before a judge. Discovery, like I said, is up next, and it's a really, frankly, quite detailed, time-consuming, costly exercise where each party essentially needs to cough up all of the documents that they have in their possession, power or control that are directly relevant to the facts on the pleadings. Power, custody and control means every document that you have relevant to the facts, whether it's an email, a text message, a voicemail, any physical copies that you have with highlighting and sticky notes, all of these need to be handed to the other side so they can read them also. It also includes things that are in your control, which means you don't have to physically have it on you in your desk or your filing cabinet or your computer. It also means that there's documents that you have access to from a third party that are yours by right, Like if your bank statements are relevant, under the discovery rules, you need to go to the bank, ask for those documents, and get them from the bank and hand them over to the other side. Mediation is up next after discovery, though like I said, this can often interchange with expert reports depending on the circumstances. Mediation is always recommended by the court now. It's part of the rules now. The court knows that it's a step, that getting people into a room face to face, preferably with a third party independent mediator, makes people sit down and discuss the issues, and hopefully you can reach a settlement without having to incur the further costs of going to court. It also means that even if you can't reach a final settlement on the matter, you can at least get in a room and discuss topics from the dispute to try to narrow the scope of the dispute moving forward, which means that you'll obviously incur less expense if it does end up going to trial. Like I said, this can often be interchanged in the order with expert reports, which are pretty much what they say on the tin. It's when you engage an expert in whatever the dispute is. Say for a building matter, a construction dispute, you might go and get a master builder who can prepare a building report for you to discuss, whether the work completed is actually shoddy, or whether what the quantum of the value of your damages you are seeking are. So if it was about a sale of a business, you might engage an expert valuer to value that business retrospectively at the time of the sale, so everybody can agree that this is the value of the claim that we're actually disputing. Like I said, this can often be interchanged because if you've got one side saying that that business was only worth $5 million and another saying it was worth $15 million, there's no point in going to a mediation at that stage if the parties can't, if they're so far apart on their valuation of the claim. A sidestep here that can happen at basically any time in the court process is offers. You can interchange informal or formal offers with the other side to settle the dispute at any time. Parties might understand that, once you get into a dispute, you can see that the costs might be blowing out and it's better to just nip it in the bud early. We have formal offers that are part of the court process, which are documents that are filed with the court, and they have very strict timelines about how and when to reply to them. And if you unreasonably deny an offer, don't accept an offer that the other side gives to you, and at the end of the matter, that offer is the same or greater than the amount that you get from winning the case all the way down the end of the line, it can be very detrimental to the cost orders that the court will make against you. If we go through all of this and we still can't come to a decision and no party wants to settle because they're too set in their ways, you will eventually make it to a trial before a judge. In our civil jurisdiction in South Australia, this will always be before a single judge. There's no 12 peers or in a grand jury there, in the jury box. It's just you, the other side, your solicitors, any witnesses, and the judge. The length of a trial can really vary. For some very simple matter, it might be just a morning, and for other matters, it might be 20 days or 30 days. And that's 30 business days that are only 6 days, 5 days, obviously, out of the week. This can take up months and months of your time. At the end of the trial, which is a complex process in itself that I obviously don't have time to go into today, but if you do make it all the way to the end, the judge will make their judgment. They have to pick a side. It might be 100% either way, but it might also mean that the judge says, well, I agree with you here, but you're wrong here, and therefore you don't get the whole claim, you only get part of your claim. They'll also make a decision on costs at that time. It's a common misconception that if you sue someone and they lose, then they have to pay all of your legal fees. That is pretty much not true in almost all scenarios. We have a party-party cost system in South Australia, which means that you'll basically get around 70%. It can vary from 50 to 85% of your fees that the judge will order the other side pays. So you can still be left with quite a chunk of the differential there that you'll still be up for even though you won. We do have a scenario called indemnity costs, which is where the court will order you get 100% of your fees, but it's only in very specific scenarios. It also might only be for certain parts of the process. And like I said before, if the other side was given an offer that was reasonable and they rejected it, that's one of the situations where the court might say everything from that the point of that offer onwards, you're entitled to 100% of your costs, because it could have been ended back then if they had just accepted that offer. Parties in this situation might also agree to just accept an amount between them for the costs. If you can't agree on the costs, then you go to another hearing where you have to put submissions forward to the judge about who should get which costs. Goes to a situation called taxation, where the judge makes that decision. And obviously, every time you're before a judge, it's just costing you more money. So sometimes parties will just agree early. We all know it should probably be about this much, just pay it, and we don't have to do that. So now we've gone through the whole court process. Let's say you've won, you've got your costs, you have a judgment, a record of monetary judgment that says this is how much the other side owes me. The court will not automatically enforce that. They won't sit there at that time when they make the judgment and say, now show us the receipt you're paying. You've basically come all of this way. It's a bit ironic, but you've come all of this way to get your debts enforced, and now you have a piece of paper from the court that is just another debt to be enforced. And so the enforcement process is just as important as the trial or the proceedings process. There are a few considerations to make first before even attempting to enforce your judgment, and some of these really are also before you enter litigation or during the entire litigation process. First, it's obviously very important the type of respondent that you're trying to chase for this money, and then also obviously their financial position. If they have deep pockets, you're probably more safe to say that that company will still exist at the end of the enforcement process to actually pay you out. But we obviously, it also includes doing things Helene mentioned earlier, like property searches or bankruptcy searches during the proceedings and during your enforcement process. Because if you're coming after them for not paying your bills as a supplier, they're probably not paying other suppliers at the same time. They might not be paying their rent or their electricity or their taxes. And if someone else gets in the queue ahead of you, there's no point in trying to wind up a company that's already in liquidation. So like I said, we obviously recommend routinely searching for these things like ASIC notices to see if somebody has either already commenced proceedings against that company or that individual, or if they've voluntarily done it themselves. The company might elect to wind up themselves voluntarily at any stage. It's also very important here to note that court judgments are only enforceable for 6 years. So if you go through all that effort, get the judgment, and then you sit on it for too long, that judgment will expire, and it's very difficult to convince a judge that they should extend that time period because you were floundering on it or forgot about it during the meantime. So if we do get to the enforcement stage, there's 3 main types of enforcement. The first is court enforcement. For individuals, we then have bankruptcy proceedings, and for a company, we have winding up proceedings. Court enforcement is quite complex. There are a number of options, and they're mainly governed by the Enforcement of Judgments Acts and also the Uniform Civil Rules. Here you've got a number of options. The top line is slightly misleading. It doesn't mean you can only enforce judgments over $12,000. It just means that the majority of these aren't accessible to you for judgments less than $12,000 because of that minor civil jurisdiction that Helene spoke about earlier. It just means, the long story short is, you have to go to the public examination first for a judgment under $12,000 before you can proceed with any of the other options, really. Our first option here is that public examination. It's also called an investigations hearing. A judgment creditor will apply to the court for an investigation summons. So the court is summonsing a person to the court for an investigation or examination hearing. This summons that the court produces, they'll give it to you, and you can either give it to the court sheriff or to a private agent, and that has to be served personally on the respondent. This means that they have no excuse to say that they didn't know that they have to turn up to court. When they go to court, the court will then examine the person. They'll investigate their financial position to see how able they are to pay the debt. For an individual, this is the person themselves turning up, or for a company, it might be the director or secretary of the company that has to do it on behalf of the company. At the end of this, if the debtor fails to appear, this is also a contempt of court. The court will issue a warrant for arrest. We had this happen in the matter 3 weeks ago. The person didn't turn up 3 times in a row, and the court said, that's too bad, we're going to bring him in now. An investigation hearing, the most common outcome is usually, especially for smaller debts for individuals, the most common outcome will be an instalment order. This is a form of payment order where the court will schedule a payment that the debtor has to comply with. Whether that's $100 a week for the next 5 years, or maybe $10,000 up front and then $1,000 up. It obviously all depends on how much they can pay and how large the debt is. The court also has the option to provide a garnishee order. These are quite rare in South Australia, but it's when the court makes an order to garnish something of the debtor. The most common form will be that they basically order that that person's wages are garnished to the creditor, which means that instead of those wages going into their bank account, they come into your bank account. In South Australia, they're rare because it needs the consent of the debtor, and there's really no scenario where you consent to that happening rather than just having a payment order. Fourth, we have a charging order. This is where a charge is placed over someone's real or personal tangible property. It's essentially a caveat or a lien. You have an order in place to put a caveat over that person's house. It might work where it effectively is a form of security that you use in collaboration with one of these others, like a payment order. If the payment order is not going to be satisfied in 5 years, you might put a charge over their house and say, well, if you stop paying at any point, we're going to enforce our charge. So if there is the possibility for them to use that charge to force a sale of the property. Otherwise, it might be an instance where you have the charge placed on the property, knowing that they're about to sell it. And when they do sell it, you're entitled at settlement for your charge to be discharged, which means the amount that you're owed is paid out of the settlement funds from that property sale. Even more uncommon than the garnishee order I mentioned is the appointment of an official receiver. It's essentially the court appointing a person to act on the debtor's behalf, which will usually be accompanied by one of these other orders. And so the official receiver will have the power to divert income from the debtor, but this is very rare. Lastly, which is far more common, is the warrant of seizure and sale. It pretty much does what it states, and it allows the court's sheriffs to go in and seize and sell a debtor's assets. This could be anything from their living in to an instance that we had where our client was a bottle maker, supplier of a winery, and the winery wasn't paying their debts. So our warrant for seizure and sale was for like 5,000 bottles of wine valuing $50,000. And the sheriffs went in and took the wine bottles. They then used those assets, obviously, to sell them at an auction. If it's something like a property and the debt is 500 grand and the property is worth $800,000, or the equity that's left over from the sale is $800,000, whatever the difference is will obviously be paid back to the debtor. They're not going to be that far out of shape. Like I said, the top line is slightly misleading. All of these things are available to debts under $12,000. You just have to start with the investigations hearing for something that's under 12 grand. Now, aside from our court processes, we have 2 others, the bankruptcy and the winding up. The bankruptcy is for individuals. They're only available once you already have court judgment. So you need the court judgment, and then the court judgment has to be for more than $10,000. The basic process that we would go through is you have the judgment, you apply for a bankruptcy notice with APSA. Once the bankruptcy notice is produced, that is then served on the debtor. They've actually made it really easy to serve debtors in this instance. You can now do it by email, or you can text it to them rather than having to serve them personally. They have 21 days to respond to that bankruptcy notice. Responding means paying the debt or coming up with a payment arrangement. They can apply to have that set aside sorry, that's the next step. The bankruptcy notice, they have 21 days. If they don't comply, which is pay it or come up with a payment arrangement, they've then committed an act of bankruptcy. Once we have an act of bankruptcy, we then go back to the court and we apply for a creditor's petition, because we're a creditor who's petitioning the court to make this person bankrupt. The creditor's petition is then, you get that back from the court. That needs to be served personally on the debtor, because now we're at a much higher stakes scenario where they set a hearing date. If they don't, at the end of the hearing, they might be made a bankrupt. So there's no excuses here for not turning up if it's personally served, like I said before. That's a creditor's petition. The debtor can apply to be set aside, except it's only in specific scenarios, being that the debt is not owing for some reason, except the only arguments you can raise here are arguments that you couldn't have possibly raised in the initial proceedings that led to the judgment. So you can't say now, oh, well, the work was bad, so I didn't pay. Now it has to be, I've paid the debt since then, so I'm no longer liable. Or if they can prove solvency at that hearing. If they can come to the hearing with proof that they are still solvent, then the court may not make them bankrupt. But what they will do is make a payment order that you have to pay this amount by this date. Otherwise, we will make you a bankrupt. If that doesn't happen, they don't turn up, or they don't make their argument, or they're unsuccessful in their argument, the court will order a sequestration order, which makes the debtor bankrupt. Once they're bankrupt, a trustee is appointed to the bankrupt's estate and takes over their entire estate. The trustee has the power to take possession of all of their assets, realise all those assets, and then distribute the funds from that realisation to the creditors who are missing out. The bankrupt is, of course, entitled to keep some of their assets during this period, like a proportion of their income, because they need that to survive. But other things like their family home could get sold out from underneath them. Bankruptcy lasts a minimum of 3 years. During that period, there are significant consequences for the bankrupts. They can't travel overseas without the consent of the trustee. They can't enter into any commercial agreements without declaring that they're a bankrupt. If you're made bankrupt and you don't own your own home, every time you apply for a rental, you tell them that you're bankrupt. I can't imagine that goes down well with the renting agent. Even if you wanted to rent a hire car, you need to tell Sixt that you are bankrupt. You also can't act as a director of any companies during that period, and you receive a permanent record on the National Personal Insolvency Index even once the bankruptcy has come to an end. Like I said, that can happen within 3 years at a minimum, and once the bankruptcy does come to an end, it's usually when the bankrupt says, I've paid out the creditors as much as I can. Any outstanding debts at the end of that will be extinguished. So it might be an instance where you only paid out a certain amount on the dollar of whatever your debt was. It's also important to note here, which I did a presentation on only a couple of weeks ago, that the trustee has very strong powers to claw back at transfers in the lead up to the bankruptcy. To make it simple, we had a client who transferred his share of his marital home entirely to his wife 3 or 4 years ago. The trustee has come after that transfer to say that property would have been in the bankrupt's estate if it weren't for that transfer, which means I'm allowed to take back that even though you did it 3 years ago. There's another instance where there was a case where the trustee looked back as far as 20 years ago to claw back at money that was transferred to someone else in order to realise that and pay it out to the creditors. Other than the bankruptcy, which is for an individual, our last topic here is for winding up, which is essentially a bankruptcy but for a corporation. A creditor of a company can apply to the court for the company to be wound up. The usual course here is on the basis of a statutory demand. Think of a statutory demand as a bankruptcy notice, but for a company. Creditors have to prepare, file, and of course serve this statutory demand on the company. It's not a complex process, but it's very detail oriented. And if there's any mistakes in there at all, the court will not accept it and they'll reject it and they'll tell you bad luck, try again. Stat demands can only be used for debts over $4,000, so it's a lot less than the $10,000 limit for an individual in bankruptcy. And the court is also very strict on compliance time here. So just like the bankruptcy notice, a company only has 21 days to respond to a creditor's petition, and the court is very strict on that. They basically will not give you any excuse as to why you didn't comply in the 21 days. Stat demands can be set aside if there's a genuine dispute as to the debt, or if there's an offsetting claim or some deficit or defect in the demand that will cause substantial injustice to the company. If the court does then make the winding up order, just like a trustee gets appointed to a bankrupt estate, a liquidator gets appointed to the company to wind it up. All the assets of the company vest in the liquidator, who will then take steps to realise those assets. They'll sell them off and pay out the creditors. All of the powers of the directors cease at that time. It's important to note here that liquidators have to pay out in an order of priority. So the first priority is the royal prerogative to the Crown. They always get what they're owed first. Then we go to secured creditors for mortgages, essentially, or property that's registered on the PPSR, like we said before. So that's your banks, obviously. Then the liquidator gets paid because they've got to get their fair share. The unpaid employee wages, the little guys next. So we're already 4 rungs down on the ladder. They get their wages and super, and then it's their extra entitlements, like unpaid leave. And then our second rung from the bottom is our unregistered, unsecured creditors. So if you have a court judgment, that's you. You're pretty far down on the list. It's unlikely in a winding up where there's not much money left over in the company that you will effectively get anything from that. There might be some form of agreements. One that was in the news recently was Big Shed Brewing. They went under a few years ago with about $8 million in debts, and creditors can come to an agreement where they get paid out for a certain amount on the dollar. So in that instance, a secured creditor might get paid out at 50 cents to the dollar, but an unsecured creditor has to take 5 cents on the dollar because it's better than nothing. I know we've mainly spoken today about the event that you're the creditor in these scenarios, but it's important to note that you might sometimes be on the other end. You might be the debtor that someone is saying you're not paying their debts. I think it's important to note here that if you ever receive a pre-action claim or a final notice or a statutory demand, it's very important to treat these things seriously and seek advice as early as possible. We so often get people coming to us saying, I received a statutory demand. Oh, when did you receive it? 18 days ago. There is not much we can do in 3 days to help you. It's best to get in as early as possible to ensure you can get the best advice. And if you do receive a final notice or a pre-action claim, it's so important to engage with the court process because avoidance and sticking your head in the sand will get you there. You can't avoid the court because the sheriffs will turn up and will drag you to court in handcuffs. So it's so important that you just engage with the process because otherwise you end up falling in. So on that lovely light note, I think that's all of us. So if anybody has any questions or any unpaid debts, then come
What I would just like to add to what Nick has said, with the stat demand winding up process and bankruptcy process, it's actually not a debt recovery at all. I've appeared before Registrar Parking in the Federal Circuit Court many times, and the Federal Court, and matters have been thrown out of court because he said, no, this is a debt recovery process, which works kind of nicely when the ATO is. But it is very important to bear that in mind. So the proper process, or the proper time you should enforce stat demand and the winding up process is, you've got a company that, hasn't paid you, let's say $100,000 or $20,000 worth of invoices, and you have serious concerns now about their solvency. So that's the right time to do it. And then the other thing about the stat demand process is you don't actually need a judgment in order to issue the stat demand. It's great if you do, because normally that's a pretty clear indicator that you're not going to be able to be able to set aside a stat demand. But you can rely upon, for example, a lease agreement where the tenant, hasn't paid their rent, and these are the outstanding invoices for unpaid rent. So there are circumstances in which, we can go straight to the stat demand process. We do have concerns and we don't have to go to the court. So I just thought I'd add that as well onto the end. But if you have any questions, please let us know. Yes.